This video, we're going to talk about the Oregon Realtors Forms Library document checklist. This checklist is meant to indicate what forms we have in the library to kind of give you a general understanding of all the forms that are in the library and what they do. The idea of the document checklist, it's document 0 in the library, is that the checklist can be used to indicate in a file or on the front page of a folder what all is involved in that file. So you could put this on the front and say we have a residential purchase and sale agreement, we have a FIRPTA addendum and a well addendum, there were seller carried documents. You can check the boxes and indicate what is being used in that transaction. Otherwise, it can be used to just know what the library that we have on offer is. It explains every document that Oregon Realtors provides. You'll note each of the forms has a numbering structure to it: 1.1, 1.2, 1.3, 5.1, 5.2, 5.3. That numbering structure is meant to compartmentalize the type of form that is involved, to speed the process of searching for forms. If you're looking for something that has to do with offers, it's a 1. If you're looking for a termination document, it's a 5. If you're looking for something related to seller carried documents, it's a 7. If you're looking for the various addendums, that's the 2s. The addenda or the addendums. This numbering structure should make it easier to look through the documents. It should have fewer instances where you're looking through 80 or 100 documents at a time. Instead, you're only looking through at most 23 documents. To begin with, we're going to go through the library and look at the documents that are on offer through the various categories. So the first is purchase and sale agreements, the ones. We have a residential purchase and sale agreement, a commercial purchase and sale agreement, a manufactured home and floating home purchase and sale agreement, agricultural land purchase and sale agreement, the vacant land purchase and sale agreement, and then various ways that modify the negotiation of the deal itself. So the right of first offer, right of first refusal, and letter of intent are standalone documents that are separate from the purchase and sale. They are in fact documents that are dealt with up and outside of the purchase process. For example, the letter of intent is used to indicate what your intended terms might be, to give you an idea of what you should write your offer as before you have to spend the time of writing the offer. The invitation to escalate is a way of modifying the offer itself to add an escalation clause to it. The 2s are the least well-defined of the areas in this checklist. It's essentially all of the addenda and the various additions that happen to the contracts. We have a counteroffer used to counteroffers, a general addendum that is used to add to or modify the transaction forms of the purchase and sale agreement, a late acceptance addendum, which is essentially a pinpoint counteroffer. It is a counteroffer with only one thing changing on it, and that is the expiration date. It's used for offers that have already expired. It's a way of creating a valid offer after expiration. The bill of sale is for the purchase of personal property that happens outside of the lender's allowances. If the loan or the mortgage won't cover the purchase of the furniture, a bill of sale is used to cover that furniture. The repair addendum 2.5, that is used for repairs. You can indicate what needs a contractor and what doesn't need a contractor. If the property was built before January 1st, 1978, you would apply the lead-based hazards addendum, and that has the protections and coverages for lead hazards. 2.7 is the FIRPTA addendum, the Foreign Investments in Real Property Tax Act. If you have a foreign person who is selling the property, foreign as defined under federal tax law, you would attach the FIRPTA addendum and it would establish escrow as the qualified substitute. 2.8 is the well addendum. If you have wells on the property, private or community wells, you would use the well addendum. The on-site septic addendum is for septic systems or sand filtration systems that are used for the on-site sewage. 2.10 is the contingent right to purchase. If you have a buyer who has to sell their property before they can purchase the seller's house, they don't have enough money available until the buyer's house sells, use the contingent right to purchase to create a bumpable offer where the seller can continue to accept offers, but they still are under contract with that buyer, and the buyer is able to ensure that they can then have that house even if the buyer's property falls through. If the buyer has available cash on hand, their house doesn't have to sell first. Instead, the buyer can just let go of this contingent right and move on to the actual purchase. The notice of intent is how the seller either says, "Hey buyer, I got a new offer that's better," or that an offer that doesn't have a contingency. You need to respond to me within a day. Or it can be used for the buyer to respond to the seller, or for the buyer to simply give notice to the seller that either the buyer is giving up their contingent right, that the buyer has an accepted offer that will lead to the sale of buyer's house, or that the buyer is terminating the contingent right offer the contingent right to purchase sales agreement. They are terminating the purchase and sale agreement. 2.12, the contingent obligation to sell, is for a seller to essentially find a replacement property before they move forward with a transaction. The wood stove addendum is what you do if you have a wood stove on the property. That is, that in any case, if there is a wood burning stove that is not a pellet stove, not an antique stove, or a wood burning insert into a fireplace, either of those cases, if you need to find a certification for it. If you can't find the certification, it must be destroyed under Oregon law. The wood stove addendum is to facilitate that structure of destroying or otherwise certifying the wood stove. 2.14 is the waiver or modification of contingencies. This is used to either release, you would give up a right before you initiate it. So for example, if you have, you're taking an inspection right in your purchase and sale agreement, you can waive that inspection before the right is ever taken. The waiver or modifications of contingencies is used at the beginning step before you've initiated the right. At all stages after the right has been initiated or at any stage in the process, you can use the release of contingencies, but the waiver should happen before you've begun the right, before you have started the inspections, before you've received the preliminary title report. Modification is also allowed in document 2.14. That's specifically for the appraisal contingency. You're able to modify the appraisal contingency so that it allows you to have low appraisals where the buyer will bridge the gap between the appraisal and the purchase price of the property. 2.16 and 2.17 are occupancy agreements. These are the instances where a buyer or a seller is moving into the property. In the pre-closing occupancy addendum, that means the buyer is moving in before closing and becoming a tenant for about a month, or up to 3 months at most, 90 days. It should never be more than 90 days. And 2.16 is when the seller is moving in to become a tenant on the property after closing, when the seller has a few months before their house is ready or the seller has not found a replacement property. The seller can create an occupancy agreement for up to 90 days to stay in their property beyond the purchase of the actual property. The buyer then becomes the landlord and owns the property, but the seller is living in it. 2.18 is the attorney review addendum. The idea of the attorney review addendum is you can allow another party to review the document or have their attorney review the document. It's a negotiative tool in most cases. You can give a party the peace of mind of being able to have an attorney review the document before they're bound to the contract. 2.19 is the FHA and VA amendatory clause. The FHA and VA amendatory clause applies to any situation where you have an FHA or a VA loan. In those instances, there are additional protections that are required of those loans and they can't be modified in some ways, so the amendatory clause must be involved. 2.20 is the base form change request. The base form change request is designed for those instances where you are asking another party to change the format of the form that they're using, to switch to a different library of forms. It's a request, it's not a counteroffer. They can deny the request and you'll proceed as though the request was never made. 2.21 is a backup offer addendum. The backup offer addendum is designed for the situations where you have multiple offers accepted on a single property. Our backup offer through Oregon Realtors has space for 2 backups, first backup and second backup. In each instance, there's a set of documents that the backup offeree must have before their offer becomes valid and live. The seller needs to prove that the previous offers, the primary offer or the first backup, have both expired or been terminated before the second backup becomes valid. 2.22 is the special tax assessment addendum. This document is designed around collecting various information and disclosures from the seller about tax assessment status of the property. So if the property is farm deferred or forest deferred, the special tax assessment addendum allows the seller to indicate that deferral status, that special tax status, and provide additional information. Lastly, in the 2.23 is the notice of completion of repairs. Once repairs are done, the seller will send the notice of completion of repairs to the buyer. When they send this notice of completion of repairs, it gives the buyer a chance to re-inspect the property and notice if there are, disclose to the seller if there are any failures in the repairs. If the seller has done a bad job on the repair, the buyer can object to the repairs and give the seller a period of time to correct those repairs. If the seller forgot to spackle the wall and there are still nail holes in it, the buyer can make that note to the seller and the seller will have to get that fixed within a couple days. The 3s are our disclosure documents. 3s are how you disclose various information that's required under either through the contract or under Oregon law. There is the seller's property disclosure statement, the seller's agricultural land disclosure statement, and the seller's vacant land disclosure. The SPDS, the seller's property disclosure statement, document 3.1, is required by Oregon law. It provides additional specialized ways of revoking an offer, and it's a special document in its own right that is required under Oregon law. Under the agricultural land purchase and sale agreement, the seller is required to provide an agricultural land disclosure. This disclosure gives additional disclosure information about the agricultural land, whether there are apiary contracts to pollinate the orchard, whether there are water rights. It gives more understanding and disclosure information to the buyer that has to do specifically with the agricultural flora and fauna elements of the property. The vacant land disclosure is attached to the vacant land purchase and sale agreement. Because a vacant land does not require a seller's property disclosure statement, there are still things a buyer should know about the land, and that's what the vacant land disclosure does. It provides additional disclosures and additional information to that buyer, where they are then able to understand how the property operates and get an idea of the property through the vacant land disclosure that they would not have gotten otherwise because there is no SPDS. Document 3.4 is the attachment sheet for disclosures. This is an additional document attachment sheet that you can add if it's necessary. On all three of the disclosure forms, if there is an answer that you answer yes and there's an asterisk next to the yes or next to the question, you're supposed to attach either an explanation or you're supposed to attach the document itself. Was there a survey done within the last 3 years? Yes, you should attach the survey, or you should attach an explanation of where the survey is or how it happened. That is what the attachment sheet for disclosures is meant to be used for. The fours are the types of property addendums. These are kind of, for lack of a better description, they are large, impactful addendums, more impactful than some of the other addendums in the twos category. For example, a new construction addendum modifies the offer significantly and adds protections for home buyers. It adds protections for liens. It creates additional disclosure requirements, and it provides additional protections and inspection rights for the parties in these new construction contexts. If you have a new construction, you would add this addendum to the underlying purchase and sale agreement. The investment property addendum is designed for when a buyer is becoming a landlord and moving into the property with a tenant on it that is not being terminated. Essentially, when the buyer is simply assuming the rights as a landlord from the seller. The investment property addendum is used to move that landlord right across to the new buyer. It is, for lack of a better description, simply an assignment and assumption contract between buyer and seller to make the buyer the new landlord on that property where the tenant lives, because it is now an investment property for that buyer. It is not being used as a residence, it's being used as an investment property that brings in passive income. 4.3 is the historic property addendum. If the property is a historic property, there are sometimes significant preservation plans that are in place to keep the property in good repair in its historic state. This can mean there's special tax assessments and tax deferrals that are applied to the property, and if the preservation plan is not met, those taxes can come blowing back onto the buyer who owns the property. If the buyer does not know about the historic property status, they can be hit with upwards of 10 years of back taxes. We want to avoid those back taxes, so the historic property addendum is in place so that the parties can disclose the preservation plan as well as the historic quality of the property. Lastly, 4.4, the association addendum, is for when you have a property that's part of an association, be that a homeowners association, a condominium association, a marina park association, or a manufactured home park association. It also applies to planned communities of any kind. The association addendum provides additional disclosures and termination rights based on the reception of the association's undergirding documents, generally bylaws and articles of incorporation, as well as the rules and policies of that association. If you have something, for example, like a condominium, you would use the association addendum to address condominium questions. In the fives, we have the termination documents. These are the ways that you can end a contract. The termination documents are specialized in the Oregon Realtors Library, and there are some documents that are new in the Oregon Realtors context. For example, 5.1 and 5.2 are notices of default. A notice of default is a situation where you have a contract where in the contract there's a promise made. Essentially, the buyer or the seller has said, I will do the following. I will provide notice to the seller that I intend to proceed with my loan. I will provide the buyer with notice that the repairs have been completed. These notice requirements don't necessarily allow a party to terminate. And when the contract does not allow you to terminate, what you should do instead when a party fails to do that thing they've promised to do is send a notice of default. These notices of default operate as ways of encouraging the other party to follow through with what they had promised to do originally. It grants if the buyer is sending the notice of default to the seller, it grants the seller a 3 or more day period to cure or fix the thing they failed to do. If the seller sends their notice to the buyer, it gives the buyer a 3 or more day period to correct or fix the thing that they have failed to do. So if the buyer has failed to provide their pre-approval letter, the seller would send a notice of default and say, buyer, You have failed to provide your pre-approval letter. I'm giving you 3 days. Please provide the pre-approval letter. If the buyer fails to cure that default, at that point, the seller is entitled to terminate using a seller's notice of termination. The default, the failure of the party to cure the default, then unlocks the ability for the non-defaulting party to send a notice of termination and end the contract. 5.3 and 5.4 are the notices of termination. When a party sends a signed notice of termination, the contract is over. It is done. It expires. It's dead. So when a buyer sends a 5.3 notice of termination, they sign the notice of termination, they check the box and explain exactly what the reason is for the termination, they provide their escrow instructions. When the buyer delivers that document to the seller, the agreement has been terminated. When the buyer sends their 5.4 notice, or when the seller sends their 5.4 notice of termination and they sign and deliver it to the buyer, and they've provided the escrow instructions and they've checked the box explaining their reason for the termination, the contract has been terminated. By sending a signed notice of termination, you terminate the contract. Once a contract is terminated with a notice of termination, the other party has 2 days to send the response. In these 2 days, the party should finish their response to termination, Form 5.5 or 5.6. In these responses to termination, the buyer or the seller respectively essentially provides escrow instructions. They provide escrow instructions that say the following amount of money should go to the following party. If the notice of termination and the response to termination, the buyer's notice and the seller's response, or the seller's notice and the buyer's response, if those two documents, when paired together, have identical escrow instructions, escrow will send the earnest money out to the party that everyone has agreed is supposed to get the money. If those instructions do not match, then escrow will not send out the money until the parties either agree or until the parties have gotten a court order that allows escrow to disperse the money. The buyer's response to termination has a special additional checkbox on it that is not in the seller's response to termination. If a seller sends notice of termination, a seller terminates the contract, the buyer has a right of specific performance. And so in the buyer's response to termination, the buyer has the ability to check a box that says, I waive and release my right to specific performance. Go ahead, seller, sell your house to somebody else. Or the buyer can check a box that says, I do not release my right to specific performance. I do not want you to sell this house to someone else. I might pursue it in court. That box is there for the buyer to indicate their plans, as well as for the seller to understand what the risks are if they proceed with putting the house on the market. 5.7 is the seller's property disclosure statement, revocation of offer. This SPDS revocation of offer is a specialized termination document that only applies to situations where you have a seller's property disclosure statement. When the SPDS is supposed to be delivered, the buyer gets a 5-day period after the document is delivered to revoke the offer. This revocation right allows the buyer to undo the contract and does not require that there be identical escrow instructions. A buyer can send their disclosure statement revocation of offer to escrow one-sidedly, and escrow will disperse the earnest money. They will undo and rewind the contract. This is only allowed to be delivered. You can only deliver a revocation of offer if there is an SPDS that was delivered and you are within the 5-day window, or if the SPDS was supposed to be delivered and it was never given to the buyer can provide the revocation until closing. But it only applies in instances where a seller's property disclosure statement is required in the contract. If you have a commercial piece of property that has no dwelling on it, there is no SPDS, and so the revocation of offer cannot be used. The 6s are our commercial documents. This is where the commercial folks will have their documents for the commercial purchase and sale agreements. 6.1 is for the assignment of a lease. If you have, for example, a building with a coffee shop in the basement, you can use this assignment of lease to assign the landlord rights over to the new buyer. The new buyer will then become the landlord of that coffee shop. This is used to assign that commercial right over from the seller to the buyer. 6.2 has the diligence documents. If the buyer is looking into the due diligence or doing their due diligence and looking into various informational pieces of the property, they can use this document request sheet to check various boxes and request various documents. Tax statements, profit and loss statements, employee roles, so you know who the employees are at the businesses that you work with, that sort of a thing. This request sheet is used to essentially provide the scope of diligence that a buyer can ask for in a commercial context. Our sevens are tenancy and lease related documents. The sevens are how the tenants are dealt with on a property. 7.1 is the tenant vacancy addendum. This is meant to be used when you have a situation where the seller is obligated to provide a termination to a tenant living on the property. If you have a tenant on the property and the seller is not terminating them, you would use the investment property addendum. The property is an investment property of the buyer at that point. If you have a buyer who plans to move into the property, the tenant vacancy addendum is how you address the removal of the tenant, the termination of the lease with that tenant, or the prospective termination of that tenant's lease. The tenant estoppel certificate is a way of certifying what the tenant's understanding of the lease is. It's also a way of creating a legal document when you have an oral agreement between the previous landlord and the tenant. When the buyer takes over the property, if they were not the one that made that oral agreement, they don't necessarily know what the rights or the terms of that contract was. And so a tenant estoppel certificate helps put in writing the terms of that lease. 7.3 is for leased or financed equipment. This is for those situations where you have a propane tank or a solar panel on top of the property that is not owned by the seller. If you have a solar panel on the property that's not owned by the seller, that solar panel is owned by the solar panel company, the solar company. That seller is just leasing it from the company. When the buyer purchases the property, you need to assign that lease over to the buyer, or remove the solar panels, or buy them outright and move them as a fixture. What you don't want to have happen is for this buyer to purchase the property and then find out there's a piece of solar paneling on the roof that is dealt with through a contract between the solar company and the seller and has nothing to do with the buyer. It's on the buyer's property at that point, and the buyer should be the one that is involved in that lease or that financing agreement. 7.4 is the agricultural tenant addendum. This is meant for those situations where you have an agricultural tenant. Because of the rights of emblements, there are additional protections that are entitled to that agricultural tenants are entitled to. And so the agricultural tenant addendum is meant to address those specialized agricultural situations. This essentially means that the tenant on the farm or on the ranch has a right to go back onto that farm or ranch to cultivate and maintain and harvest crops that they placed. Those additional rights for tenants are very significant and need to be in place when you're moving a tenant's rights over to the buyer. In addition to that, the agricultural tenant addendum has provisions that allow the seller to also become a tenant on the property. So if the seller sells the orchard but wants to continue farming the orchard, they just don't want to own the farm underneath it. They want to become a tenant farmer after selling their own property. There's a provision in the agricultural tenant addendum that allows you to facilitate that process. Our the 8 documents, these are seller carried documents. If you have a seller carried transaction, that is an instance where the seller is essentially acting as the bank. They are financing the loan for the buyer to purchase the property. The buyer says, I don't have $500,000. The seller says, I will lend you $500,000, but you have to pay it back to me as though I'm the bank. That is a seller carried transaction. Anytime you have a seller carried transaction, document 8.1 is involved. This is how you provide the terms for the seller carried transaction, as well as it provides additional protections and rights for the seller, such as the ability to do credit checks or background checks on the buyer. The seller should not just be making these loans willy-nilly. They should make sure that they are comfortable with the party they're lending the money to. The seller carried addendum also provides a scrivener's agreement provision, which says if you are a broker who is involved in this seller carried transaction, you are merely a scrivener. You are just writing things down. You're not providing advice. You're not providing guidance. You are merely an advisory body. For the seller carry transactions, your 2 options for a seller carry is either a promissory note and deed of trust, where the property is transferred to the buyer, and then the buyer provides a deed of trust to put the property in trust as security on a loan, the promissory note, or a land sale contract, where the seller has not transferred the property to the buyer, but rather they're in what amounts to a rent-to-own agreement with that buyer. In a land sale contract, if the buyer fails to pay on the land sale contract, the seller can strictly foreclose, and the buyer would be entitled to no equity under the contract. In a promissory note and deed of trust circumstance, if you have to foreclose on the property based on failure of the promissory note payment, at that point the buyer who owns the land would have an entitlement to whatever equity they've accrued in the property. And so the difference between promissory note and a land sale contract is largely it's the equity question of what happens when the contract goes wrong. These documents are designed to help you address these land seller carried situations. With that said, it is generally advisable if you are a broker or a realtor to have a conventional mortgage be used in the process, or to allow an attorney or to allow escrow to draft the seller carried documents. It is the most legally dangerous place you can probably be as a broker, so you should generally avoid being involved in seller carried transactions if possible. In our nines, the nines section, this is where we have our various agency documents. This is the way that you and a client have a relationship together as agent and principal. 9.1 is the final agency acknowledgement. This is essentially a document that's on the front of every purchase and sale agreement. It's required under Oregon law, and it's a disclosure of all of the agents involved in a transaction. If you have multiple transactional agents, you have a team with 3 or 4 agents on it, all of them should be in the final agency acknowledgement. If you have a transaction coordinator or an assistant who is doing professional real estate activity and is licensed in the state of Oregon, they should also be on the final agency acknowledgement. To see whether or not your assistants are technically considered agents that would need to be on the final agency acknowledgement, consult ORS 696-010 Section 17, where professional real estate activity is defined. 9.2 is the disclosed limited agency agreement. It is used if you are representing both buyers and sellers, or representing many sellers in a transaction. The disclosed limited agency agreement needs to be in place before you begin your secondary representation. If you are a listing agent and a buyer comes up and says, I want to purchase this property, can you write an offer for me? You need the disclosed limited agency agreement in place with your seller before you can even begin the representation of that buyer. So have these disclosed limited agency agreements set up at the start point rather than the middle or the end point of your transaction. 9.3 is the listing agreement. This is a way that you can represent a seller. It provides protections and context for how you are representing the client, as well as the ways that the contract is terminated and the ways you are entitled to commission. It also states what the seller authorizes you to do, how they authorize you to advertise the property, or whether they authorize you to put a lockbox on the property. 9.4 is the buyer representation agreement. This is the way that a buyer will be represented by their agent. It sets up the purpose of the buyer's transaction with their agent. It establishes what the range and scope of the representation is, what the buyer is looking for, if they want to lease, if they want to purchase, what they want to purchase. It also provides the expectation of payment, or the way that compensation will be addressed if a property is found that the buyer wants to purchase. The non-agency agreements, 9.5 and 9.6, are designed for agents that when an agent is in a transaction with an unrepresented buyer or a for sale by owner seller. In one of these cases, you want to make sure that the other party, the non-represented party, understands that you as an agent do not represent them. You are the seller's agent. You are not the buyer's agent. You are the listing agent, or the buyer's agent. You are not the seller's agent. The non-agency agreement essentially asks the unrepresented party to recognize, ratify, and acknowledge that they are not represented by an agent in this transaction. By signing these agreements, they set up their understanding, and they indemnify you against lawsuit, where they can't claim in a court trial later on, well, my broker told me the following things, because you aren't their broker, and they signed a document understanding that you are not their broker. In the seller's, 9.6, the seller's non-agency and fee agreement, we also have the fee agreement in there. So that's how the buyer's agent will be paid in one of these transactions, with a for sale by owner client. 9.7 is the conflicts of interest disclosure. This is used in any instance where you as an agent have a conflict. This is a situation where you have a financial stake in the outcome of the transaction that is other than the compensation agreement that you have with the client. So for example, if you are a buyer's agent and your sister is selling her house and your buyer wants to purchase your sister's house, in that instance, you need to disclose to your buyer directly, my sister is the seller of that house. If this house is sold, she will make money. That is an indirect conflict of interest, and I need to disclose it to you. This conflict of interest disclosure form is used to disclose those conflicts, to tell the client when you have potentially difficult loyalties. If you are worried about the client's interest, or if you're more worried about your sister's interest, the client needs to know when those possible wavering loyalties can exist. And that's why this disclosure form should be used regularly. 9.8, the Notice of Real Estate Compensation, is an Oregon statutory document that establishes the seller's understanding of the right of compensation, or the agent's understanding of a right of compensation. The Notice of Real Estate Compensation is sent to the escrow company in most cases before closing, so that escrow understands where money should be going. When a buyer and a seller close a transaction, if their understanding was the seller's agent was only going to get 2% of the listing cost, and the agent's understanding was there was 3% of a commission that went to that agent, that's when you would want the notice of real estate compensation to have been sent in earlier. If escrow sees discrepancies, they'll pause and address those discrepancies, but you need to send in the notice of real estate compensation to even get escrow to be thinking about possible discrepancies. Those are the 9s. The 10s are the advisories. This is the last section in our library, and it's the section that is the least formulaic or the least legal. It is advisory language. 10.1 and 10.2 are the buyer and seller advisories. These advisories are paper shields for the client and paper shields for the broker. You provide a buyer or seller advisory to your buyer or seller respectively, and these documents should explain to the client the possible risks involved in a transaction. If you're looking at the square footage of a house in the listing, and that was the reason why you wanted to put your offer on it as a buyer, you should know that square footage is not necessarily accurate on the listing. And so if that's the core reason why you put your deal or your offer down, that it was a 1,600 square foot house, you should know, and the advisory tells the buyer, you need to actually measure the square footage because it's not guaranteed if it's just in the listing. These advisories provide essentially warnings and statements to clients to let them understand the possible risks that they are going to have in a transaction. It provides advisory warning statements. It provides advisory educational statements to the client. It also has a section at the base of each page of the advisory for the buyer and seller where the buyer or seller can initial the page. The initials on that page are what protects the broker. It's a way that you can, in court or in an arbitration or a mediation, if you have to, you can say, my buyer did read this page, as you can see, because they initialed the page. They were on page 9, at least long enough to initial it, which means I did my job and gave them the information they needed to protect themselves. In addition to all of my phone calls with them, it provides a paper trail that you have done your job in providing educative and preventative care to your client as their agent. 10.3 is the lead-based pamphlet. This is the Protect Your Families from Lead in the Home pamphlet. This document is provided in English as document 10.3. On the actual lead-based hazards form, you'll note that there is a link to a website for the EPA that has additional languages for this pamphlet. If you are a seller delivering the lead-based pamphlet to the buyer, which you are supposed to under federal law, you should deliver that pamphlet to the buyer in the language the buyer is signing the contract in. So if the buyer is using a Spanish language form, you should be using a Spanish language lead-based Protect Your Family from Lead in the Home pamphlet. On the EPA's website, which you can reach through the lead hazard addendum that Oregon Realtors has on offer, you can find the various languages. They come in 12 separate languages. 10.3, however, the one in our library, is only in English. 10.4 is the initial agency disclosure pamphlet. This is the one that is provided by OREA, the Oregon Real Estate Agency. It provides a description to the client of all the ways that an agent is supposed to represent them and how representation and agency works as kind of a broad strokes explanation and education for the client. You should always provide the initial agency disclosure to your client when you are representing them. Lastly, 10.5 is the wire fraud advisory. Wire fraud is a serious problem in the state of Oregon as well as nationwide. And so the wire fraud advisory, while there is wire fraud language in the buyer and seller advisory, 10.5, the wire fraud advisory, is additional documentation. It's a faster and easier way to provide strict and direct information to your client about the risks of wire fraud. It's not wrong to provide the buyer advisory and the wire fraud advisory to your buyer. It just ensures that the buyer has 2 chances to look at wire fraud information and to possibly avoid a tragic wire fraud problem. That is our entire library that we have on offer. We advise that you look through the actual training guides that we provide through Oregon Realtors and become educated on the individual forms and how they work. But if you're just wondering about broad strokes of what's in the library, we thank you for spending the time that you've spent learning about the documents in our library today.